Number 27, People versus Debellis.
Good afternoon. May it please the court, Matthew Bova for Mr. Debellis. I would request 2 minutes for rebuttal.
You have 2 minutes, Mr. Bova.
Defense counsel here conceded weapon possession and failed to request the only applicable defense, effectively directing a guilty verdict against his own client. This was not meaningful representation, certainly not the meaningful representation that the state constitution mandates.
So what in the record supported that defense?
So Mr. Debellis' testimony. So at the time that counsel is analyzing this issue, we have to really look at the charge conference and see what is before defense counsel as far as the record goes and what the law is. Mr. Debellis expressly testifies that he goes to Carmel, removes the firearm from the safe, brings it to the Bronx, and that he is going to turn it in exchange for cash under the NYPD buyback program. That testimony has to be credited for the purposes of a defense instruction. But defense counsel...
There has to be a reasonable view of the evidence that supports that testimony, doesn't there?
No.
No?
Because under the law, under Watts, and the long-standing rule as far as reasonable view goes, you'd credit the defense evidence, and here it's the defense testimony. And it becomes an issue of credibility for the jury.
But
now,
what if there's conceded evidence and there's no reasonable view of that evidence that supports that charge?
So the question that underlies the charge is whether or not he is in fact in the process of voluntarily surrendering
Right.
a
So
weapon.
what about a hypothetical where, same facts, hypothetical though, on the way down to the Bronx, he stops off and robs somebody, not with a gun, but with a knife, and they pull him over, and he says, I was on my way to the buyback program to give this gun back. Does that destroy your buyback defense for the gun?
I don't think it, I think that goes to the jury because you still have to
Yeah.
credit it because it's not factually impossible, but those facts are completely different because it would be very difficult to persuade a jury on those facts that you want to participate in this buyback program, which is a lawful, sensible thing to do if you want to get rid of a gun and acquire the money.
Is there some point where it could become so unreasonable that you'd say, no, it doesn't have to be credited? For example, he testifies, I was driving along the expressway with my sunroof open and it dropped into my car. Still have to give the instruction? And I decided I would take it to the Bronx to turn it in.
I mean, I think that sounds completely implausible, but under the law, you get the instruction. I mean, this is not
And the jury has to decide whether they're going to believe that or not.
Yes, but these scenarios are completely different than what we have here. This is the scenario that will come into play when someone is surrendering a firearm. It's very similar to Watson.
And how is this defense impacted by the existence of an order of protection to the benefit of the wife that he was supposed to have surrendered already weapons?
So the fact that there's the order of protection actually confirms counsel's ineffectiveness because from start to finish of this case, counsel is trying to get this issue in front of the jury. He's trying to get this jury to determine whether Mr. Debellis is credibly alleging that he is on his way to the buyback program.
So
but
was he
instead of
trying to invoke sympathy? The judge suggested that he was trying to get nullification because he was putting sympathetic facts. He had a fight with his wife about money because he lost his job.
But sympathy is no substitute for a real cognizable defense. Jury nullification and mercy plea, those are not real defenses.
Does it matter in this instance? The defendant appeared sometimes, didn't appear. He had different views of what should be offered. At one point, he wanted to offer evidence that he was sexually assaulted when he was being searched.
No, that has no bearing on the question of whether counsel was ineffective for failing to request the instruction. Because the question is, what is the record that counsel is looking at? But I just want to step back, too, in terms of the meaningful representation question. This is not a case involving an absurd fact pattern that counsel believes is a terrible defense. From start to finish in this case, counsel's factual theory, from opening through hundreds of pages of colloquy about what the defense strategy is that Mr. Debellis is driving his car with the weapon to surrender.
I'm confused, that colloquy. I've read it, the 1306, whatever. And they seem to talk about a buyback program in there as well. But we don't force counsel to ask for an instruction that they wouldn't be entitled to give, which is why I'm asking about the buyback instruction. I've watched the video and listened to the accompanying audio, and the police repeatedly ask him, the police that he's supposedly going to their precinct to turn over a gun, do you have a gun? And he says no, on the video, and you can hear it. So how is that possibly compatible, a reasonable view of that video, which there's no question is authentic? How is the defense, I was going to turn this in, compatible with him telling a representative of the police force he's going to supposedly turn the gun into, I don't have one?
Well, because Mr. Debellis actually directly addresses that in his testimony. He says, I didn't think it would do any good. Because a sensible person could certainly say, if I advertise to this police officer that I'm on my way to the buyback program, he might not believe me, and instead he's going to arrest me.
It's not even that. You know, it's not even that he says I don't have one, which he does, but he takes him 2 minutes to pull over when they're behind him, and then at the very end of the video, he goes in and is doing something in the area where the gun is, and that's how they find it. So all of that evidence, which is, again, on the videotape and on the audio, is completely inconsistent with his defense.
This debate that we're having right now, I think is exactly the debate that the jury should have had during jury deliberations.
No, this is the debate that the judge needs to go through in deciding whether the evidence is a reasonable view of the evidence supports the charge.
Well, under the reasonable view standard since time immemorial in this court, Watts, every case involving reasonable view is you look at the evidence that the defense presents and you credit it. If it's a question of,
You just credit it just like that, just because he said it?
if it's a question of credibility, yes, Your Honor, it goes to the jury.
Well, what about objectively? Like, what are the facts that support his statement that he was going to the buyback
Well,
program?
he also testifies that he had a horrible work accident, had his finger sawed off from falling from a ladder. He's fallen on hard times, goes home
About the
to get-
buyback program. Under 26520, there's a second part of that says, "The same shall be surrendered in accordance with such terms established by the superintendent, sheriff, etc." There's no evidence of that in his testimony. So why isn't it, even under Watts, why isn't a judge allowed to say, I don't find that that's a reasonable view?
So the first
I'm
thing...
not submitting it to the jury.
So the first thing is that Watson, which at the time was decided a year before this trial, simply says that where there's evidence indicating that the defendant is in the process of surrendering the firearm, the issue goes to the jury. That authority was available to defense counsel, and defense counsel, the only way he misses that is because he's not doing research into this defense.
So that evidence for you is a self-serving statement that I was going to return this, despite what the evidence overall at the trial, including the 3 hours in the video, the fact that they waited an hour before they even found a gun, a judge wasn't allowed to consider that in determining what's reasonable to submit to the jury?
No. And this was never even presented to the judge. The reason why the judge rejects the absurd defense that defense counsel presents, because I just want to step back a second and
I
focus...
understand that argument, but this is relevant to whether he was ineffective for not requesting the charge. That's what this is relevant to. I understand your argument that he only argued for the temporary lawful possession on the common law. But if we're going to assume, we're going to take up that argument that he was ineffective for not requesting this charge, we have to look at whether the charge would have been given or not, and that's how it's relevant here.
So as to whether the charge is given, Watts holds that you credit the defendant's testimony and send the issue to the jury. What ends up happening here is defense counsel is pursuing this factual defense. Defense counsel thinks this is a reasonable enough defense to present to the...
Are there two separate charges, or two separate defenses here? There's temporary lawful possession, and then the statutory, I'm going to a buyback program. Are they separate or are they the same?
Oh, no, they're very separate. So the voluntary surrender defense under 26520 simply requires that a person be voluntarily surrendering the firearm to the NYPD precinct. The temporary and lawful possession defense requires that you only possess the weapon only as long enough as necessary to turn it in.
So the error is the way he proceeded down the wrong path? Is that your argument?
Absolutely. Defense counsel pursues one factual theory, which is he's in the process of surrendering it, but he chooses the wrong legal defense. He chooses an absurd temporary and lawful possession defense, even though for pages and pages of colloquy, the prosecutor and the court are beating him over the head with the argument that this is not temporary. You're conceding that, that your client had this firearm for over a year unlawfully and didn't turn it in. There's nothing
But it's
temporary.
clear the statutory buyback doesn't matter how long you had it.
Yes, there's no temporary requirement. So what counsel does is he hoists an element onto his case that he didn't actually have to satisfy, which was the temporal requirement. Instead, what he should have done, what any sensible lawyer would have done, was said, I have this factual theory, I need to convert it into a defense that will give this jury the opportunity for acquittal.
Was he
Instead,
challenged by the fact that there was no standard jury charge, CJI charge for it? For the statutory buyback?
No, it doesn't matter that there's no CJI defense, because effective counsel has an obligation to request any defense available, whether or not there be a CJI defense or not.
Is that because it could still be crafted by the court, the charge?
Well, at that point, what he should have done was he should have said, Your Honor, under 265-20, the jury needs to be instructed that if they determine that Mr. Debellis was in fact on his way to surrender the firearm to the NYPD precinct, that is satisfying the terms of the defense. That's the instruction that he never asked for. So instead of this whole argument that we're having right now on appeal, this all should have been hashed out in the jury deliberation room with a properly charged jury. Instead, all Mr. Debellis gets is no defense at all and a concession of guilt. And meaningful representation, if it means anything, means that when counsel is trying to present a factual issue to the jury, and when there's a legal defense available, he has an obligation to request that legal defense and not simply admit guilt and direct a verdict
But
against
sometimes
his
defense
client.
attorneys choose defenses that, in hindsight, would have been the wrong one. So we're to punish him and call him ineffective for choosing a defense that ultimately didn't prevail? I mean, these choices are made.
No, but he didn't pursue the defense he didn't pursue any defense that was valid.
Didn't he pursue that defense and the judge was actually on the fence about giving the charge for a while? And then he makes the determination after he testifies? Against advice of counsel?
So what the judge repeatedly tells counsel is, I want to remind you that the CJI requires
At
temporary.
one point say, I'm inclined to give it?
When they're talking about the defense, yes, he does indicate that, but he also keeps
How can that be
saying,
a frivolous defense if at one point the judge is saying, I'm inclined to give you the charge? And
Because-
that's late in the trial. I think it's after the people rest.
because at that point, there's no evidence as to how long Mr. Debellis had
And then
actually.
he testifies.
And then he
against advice of counsel.
But he testifies. So from the beginning, counsel knows that when Mr. Debellis takes the stand, he is going to admit that he is possessing the firearm and on his way
He's
there.
advising him not to do that.
The whole time, no, because at one point, defense counsel does say that, but defense counsel opens on an admission of weapon possession. He opens on the buyback program.
But
In
at that
opening,
point in the trial, which again, I think is after the people rest, the judge indicates, I'm leaning towards giving you the charge.
he does say that, and then
The client
common sense prevails with the judge, and he says, as I've been telling you over and over again, temporary is required.
And he's gotten on the stand at that point and said, I had the gun for a year, right?
Yes, and that is why he's unreasonable, because what counsel's doing is once his client testifies, as he knew he was going to testify from the very beginning of this case, once he testifies that he's had it for a year.
Decision he has to make himself, the client, obviously it's his right to testify or not. And if you've got this one defense and you're advising your client, no, don't testify, and maybe you think at the very end, since we've got this fairly good ruling by the judge, he's not going to get on the stand and I'll get my instruction. And then he decides to testify against that advice. Now you're saying that's no defense ever, never. He knew from the beginning.
Just to correct the record, though, Your Honor, at A1103 through 06,
Right.
what happens is there's a discussion of the proffer And the judge specifically tells him, you cannot get this defense without putting Mr. Debellis on the stand. That makes complete sense because there's no evidence until he testifies about the buyback program, about anything the counsel's trying to establish.
Colloquy in a way, because they're also talking about the buyback program in that colloquy. They're not only talking about, you don't need the buyback program to have temporary lawful possession, right? So I don't understand that discussion in there.
So it's hard to understand because it's an incomprehensible defense that counsel's trying to present under the common law defense.
But
Because
it
what
could
his
be that he says you don't get the buyback defense unless your client gets on the stand, right?
Well, and also a temporary and lawful possession defense because there's no idea at that point until he testifies as to the duration. But what counsel's trying to do is he takes the position that, well, he has the gun for at least a year and a half in a safe, but after that period elapses, he temporarily decides at that moment to get the gun and bring it to the
But
precinct.
couldn't it be argued that it was in a safe that he was not in possession of because he wasn't living in the house because of the order of protection?
No, for two reasons. The first reason is that Mr. Debellis Mr. Debellis, in March of 2017, when he's convicted, at that point, he loses the ability to have the firearm under the law, under the penal law. So at that point, he had to surrender it. So the fact at that point it's in the safe, he has an obligation, as the judge tells defense counsel, to turn it in and surrender it. He can't just leave it there.
That is true. So you're saying his constructive possession, so even if it's at the wife's house, in her actual possession, it's still his responsibility, he's still possessing?
Yes, because he has an obligation to turn the firearm in.
Even though he doesn't have access to it because he has an order of protection that says, I can't go to that house?
Well, as a factual matter, he does have access to it because...
I know, but they could have made that argument that Judge Troutman is just making. I mean, the crux of both of these is a voluntary surrender of that weapon. And a defense attorney may have decided, you know what, I'm not going to go with buyback after he's testified because he can't give any details about this buyback program. And he's passed a number of police precincts along the way and didn't stop to give over his gun. So I'm going to try this, that maybe it was the difference between actual possession and constructive possession. It's still a voluntary surrender. That's the defense I'm going with. Why isn't that equally reasonable?
No, because on this record, what happens is counsel, after Mr. Debellis testifies, uses the buyback theory in service of the temporary and possession defense. And even if any of these other defenses were remotely plausible, which they're not, but even if they were, once the judge shuts it down and says, I'm not charging that, counsel has an obligation to say, well, my whole factual theory here has been buyback. I'm going to request the defense that's tailor-made for that so I can actually have an issue for this jury. Instead, he doesn't do that, and we have a directed
Any
verdict.
reason he couldn't seek both? Anything incompatible about them?
No, not at all. He could have absolutely sought both, but he goes all in on the one that makes no legal sense whatsoever and ignores the one that simply requires the jury to determine the credibility of the precise factual theory that he's been
So
presenting
your
to the jury.
argument is that he presented the defense as if the statutory did not exist?
Yes, Your Honor. Yes, he develops the factual predicate for the 26520 defense, goes all in on the temporary and lawful possession defense, which has no basis in law, as the prosecution concedes and has argued throughout these proceedings. The prosecutor tells defense counsel, your defense has been demolished by the fact that he possessed it for a long period of time.
Okay.
At that point, he should have requested the only available defense.
Thank you, counsel.
Thank you.
Pardon me. Good afternoon, Your Honors, and may it please the Court. Reva Grace Phillips for the respondent, the Bronx County District Attorney's Office. Your Honors, defendant asked this court to miss the forest for the trees. But this case is clearly not just about whether or not defendant was entitled to a specific charge, but whether counsel was effective. And I think more importantly, as Your Honors' questions highlighted, whether or not the court had a sufficient record before it, and this court has a sufficient record before it, to make that determination.
Counsel, I look at this statute, 265.20, and it says a person voluntarily surrendering such weapon, instrument or appliance provided that, et cetera, right? And then you're exempt from the relevant penal statutes. So it's simplest, it seems like an act of production immunity almost, right? So the obvious case would be I walk into a precinct, they have a gun buyback program, I hand the gun to the officer, they can't arrest me and say you were unlawfully in possession of that weapon. under the statute. But it has a logical component to it that says if I stop you outside the precinct on the steps and I'm walking into the precinct and I'm going in to do the buyback program, it's not simply the act of production of me handing it over. I shouldn't be prosecuted if I'm on the precinct steps, right? So how far back do we take that under a reasonable view, of this statute? And what breaks the chain?
Your Honor, I think that's a very fact-specific question here, and to focus on the facts here, this defendant traveled for over an hour with this loaded firearm and with a bag of ammunition and a spare magazine that was fully loaded. Counsel relies heavily on the case People v. Watson. The defendant in Watson, the court noted there, the Second Department noted, that the fact that Mr. Watson had a holster, had spare ammunition, and had a loaded magazine clipped into the gun was good evidence that he did not intend to go and surrender it. The same is true here. This defendant had a large amount of ammunition on him, including a backup magazine. As Your Honor's questions correctly pointed out, when he was asked by the officer numerous times on video, where's the gun? Do you have a gun? Hey, I see a holster. Where's the gun? Defendant says there is no gun. Defendant goes further.
Why isn't counsel correct that those are all questions that go to his defendant's credibility and go to the jury? They're the finders of fact and they're determiners of the credibility.
Well, again, I think Your Honor's correctly pointed out that to get to that point, to get that instruction, you first have to have a reasonable view of the evidence that entitles defendant to that instruction. Here we don't. Again, the video evidence is uncontradicted. Defendant's own testimony, is essentially, oh, well, it wouldn't have done
What's
me any good.
problematic about the video evidence? Is it so unreasonable to believe that someone who has a gun, who's gone through this issue and with their spouse and is leaving under not the best of circumstances, is desperate? This is his testimony, we got to take it for what it is. Desperate for funds, is stopped by the police, is not immediately going to say, yeah, I got a gun right there.
Your Honor, I think additional
Or
facts...
say, I'm going to the buyback program, who may be suspect as to whether or not they're going to be allowed to pursue what he claims was his purpose and intent with having the gun in the car to get to the buyback program.
So, Your Honor, I think defendant's testimony, again, sort of blows up his own request here. Defendant testifies that he looks into whether or not there are precincts in his area, that he looks into where there are buyback programs. On cross-examination, though, he admits that he was unaware that there was an upstate buyback program just 3 days before he was stopped by Officer Allen. He acknowledges that he knows there's all these precincts he's passing. And I think, very importantly, he does not testify that the 49th Precinct actually has an ongoing buyback program at the time. And as the court says, it does its own research, there is no buyback program at the time. And I think it's important to distinguish between a buyback program and the fact that the NYPD will allow you to surrender under 265-20 at any point. Not every precinct at every day is having an actual buyback program where they will give you cash for the gun. That program actually rotates, and I think Your Honors can take...
That may be something that he's not fully aware of, but the fact that he had this intent, the question is his intent. He says, this is what I was going to do. The fact that he may not be successful in that moment because the precinct is not the correct one strikes me as not the issue regarding the charge. Because this is all about whether or not you get the charge, not whether or not the jury should believe him or not believe him.
Well, I guess I would respond with 2 points. So the first being, again, I think defendant's testimony undercuts the idea that he's going to actually go to a buyback program because, again, he says he did this research. So he's saying in his own testimony, well, I looked into it, and that's why I thought I was going to get cash.
I research all kinds of things and miss something sometimes, right? I mean, again, it seems like it goes to credibility.
Again, Your Honor, I think this is all sort of in the totality of defendant's testimony and the fact that he has these orders of protection against him for over a year and he has this open case and, he also loses his permit. It's the totality of defendant's context and his own testimony and the video and everything that piles up to make it so that there is no reason.
I'm not so sure that works because, I think the gun buyback program is aimed at people who may have a gun where they still have they have an order of protection or they may have even committed a crime with the gun before. But you want the gun off the street. So there's an incentive, all right, I haven't complied with that order of protection, but now I'm getting the gun off the street. I thought that seems to me kind of the whole purpose of the gun buyback program.
I would absolutely agree with Your Honor that the point of the buyback program and the point of 265-20 is to encourage folks to give their guns up. But it's
Right.
to encourage them to do that locally and to do that without traveling and causing this sort of reckless situation, which the court actually talks about in one of these colloquies where it talks about, am I going to give this charge or not? He says, I'm also considering the fact that he sort of recklessly takes a loaded firearm on public transit, and then he's in an unregistered vehicle.
But what does that have to do with the fact of his intent? What does that have to do with that? I mean, maybe they won't accept the gun when he gets there, but what does that have to do with the charge?
Well, Your Honor, I think it goes to whether or not, again, there's a reasonable view of the evidence here, and I think the court expressly says, I'm considering the public policy ramifications. The point here is to
Because he's
encourage.
reckless in pursuing the buyback program?
Well, I think the court is talking about if the point of the public policy interest here, and I'm trying to give effect to that, is to encourage surrender. Then
Yes, no
it's-
questions asked, right? No questions asked.
No questions asked. However, Your Honor, I would note, I think defendant cites to a Wayback Machine link. I think this goes to another point I'd have, which is this really should be raised by way of a 440 motion. That's the criminally recognized way of having a Wayback Machine. But I think in terms of this question of, was he actually on his way to the 49th for any kind of, buyback program, it's an open question. And if Your Honors actually look
Are
at
there
the...
two different charges that could have been pursued here?
I do believe the defense counsel could have requested two defenses. However, the fact that defense counsel didn't request both defenses doesn't render him ineffective. Defense counsel may reasonably and strategically decide to pursue one defense without the other for any number of reasons.
But they're not incompatible, so what would be the reason not to ask for the charge that better fits his testimony and better fits the opening?
Your Honor, he could have felt, for instance, that if he presented both to the jury, that this would muddle the jury's, interpretation of the issues. He could have felt that the trial court would select which one it felt was better, and he wanted to pick the one that he thought was going to be more convincing.
But he's pretty much, I mean, maybe you see the record differently, but counsel's arguing, but he's pretty much argued it. He's just not requesting the charge. He's pretty much done what I think you fear, which is presenting scenarios that would confuse the jury or direct them in one to come out instead of an acquittal with a guilty verdict. Yet it seems these are the things he's done. He's just not gone the last step that counsel argues is logical and what any defense lawyer in his shoes would have done, which is then say, well, give me the charge. We've laid the groundwork, give me the charge.
Right, Your Honor. And so I think that, again, this should be raised by way of a 440 motion because we simply don't know why defense counsel selected one of the strategies over the other. As I was about to say, the NYC City official website, gun buyback program, directly instructs if you intend to surrender, call the police precinct first to let them know so that they can tell you what the proper policies and procedures are. That's the website today. This 440 hearing would allow defendant to explore what did that look like at that time. And I think it's reasonable to believe that this defense counsel could easily have read the McKinney's instructions we cite in our brief, could easily have asked his defendant, hey, did you look into this? Did you actually call the precinct? Because it says online you should. We don't even know actually where defendant's address is at the time. From this record, we don't know where his mother's house is, where he's living. We don't know if defendant considers his mother's house his residence. Under 26520 and under People v. DeTore, there has to be strict compliance with policies and procedures of the local precinct. We don't actually know if defendant did any of that
I'm
groundwork.
still having difficulty. So the jury doesn't go for it. Okay.
Oh, and Your Honor, I
But
think...
why not ask for it? Once you've laid the groundwork for it.
Well, again, I think that, defense counsel chose which of the defenses he thought he was more likely to get based on the judge's ruling. Judge Troutman went into the
Well,
constructive possession
Even
part.
if you thought that, once the court says, okay, you're not getting your first choice, why don't you then say, okay, I've got Plan B here?
Again, I think that for the same reasons the court is denying the common law instruction, the court is signaling it would deny the statutory instruction. And just as Your Honors asked counsel.
Really?
Yes, Your Honor. I mean, the court is engaging in an in-depth colloquy talking about the buyback program, and he's saying, I find it really hard to believe he was actually on his
Anyone point the statute
way.
out to the court? No, right?
Pardon me?
Nobody's pointed the statute out to the court at all.
Not that we're aware of. Again, we don't know what was said at all of the bench conferences. We don't know what defense counsel and defendant talked about.
Couldn't the defense attorney have just said, you know what, I'm not going to go with either of these. I'm going to go with, this is sort of a pathetic person who's down on his luck, who's, leaving, his wife asked him to move out. I'm going to go for sympathy and pity for the jury. I know if I ask for these charges, that technically, once they hear the charge, I may not meet those requirements, and then that'll water down my sympathy defense. I mean, why isn't that a legitimate defense that an attorney could pursue?
I think that's absolutely a legitimate defense, and I think that from the record
Why
we
isn't
see...
it sympathetic that he's trying to get money from the buyback program because he's financially desperate?
Well, Your Honor, in the court's colloquy with defense counsel, where he's talking about what he needs to get over his problems with issuing this charge, he talks to counsel and he says explicitly, I don't want to blindside you, basically. If he testifies that this is temporary and honest possession, it's going to open the door to these orders of protection. And defendant's decision to testify against counsel's advice opens him up to a devastating cross-examination where he has to admit he has orders of protection that ban him from seeing his children and wife. So it directly cuts against his sympathetic defense where he is saying, you know, I was a great father, I care for my autistic son, all of these things. And then to have him on cross say, oh, well, but there are 2 orders of protection actually banning me. And defendant even tries to be cute and say, oh, well, actually that order, no, that's a temporary order.
Counsel,
And-
to that point, and I
Yes,
see
Your
your
Honor.
time is up, but the way this works, if he raises the defense and the judge says, okay, you've raised it, do the people get an opportunity to rebut?
Yes, Your Honor. I believe if the court was going to issue the instruction, they would give the people an opportunity to rebut.
And we don't know on this record what that rebuttal would have looked like because he never raised the defense, right?
I think that we can have some sense of what the rebuttal would have looked like because the people had already put in
You
a
would have
substantial
more
amount.
of a sense if you had a 440, right?
That's absolutely right, Your Honor. And for those reasons, this court should affirm the division's decision and find that this should have been raised by way of CPL 440. Thank you, Your Honors.
So the ineffective assistance analysis focuses on the relevant period at the record, which is the charge conference. Counsel has an obligation to request the charges based on the evidence. So once Mr. Debellis testifies, he has to request defenses based on that.
At the point your client says, I don't have a gun, is he unlawfully in possession of it from that point going forward? I mean, even if he was really going to bring this to a buyback program, and a police officer pulls you over, and he says to you, do you have a gun, and you say no, how is that compatible with I'm taking the gun back? Even if you were before that, isn't it from, because what I'm struggling with is this chain, how far back can it go, and do you always have to just give this evidence, again, if the gun falls, to say the gun fell from the sky? So, at that point, where the officer of the precinct that you're supposedly turning it into says, do you have a gun, and you say no, aren't you from that point forward unlawfully possessing it?
No, because the statute says that someone who is voluntarily surrendering the
But you're
firearm,
not anymore. You're saying I don't have one.
but the statute grants immunity for those that are doing it. So this off and on immunity,
You're doing that. Not forever,
but you have done it, you are in the process of doing it.
but I rob a bank with it, but I was in the process of doing it. I still have immunity from the possession count?
No, because on those facts, if you're robbing a bank, it's impossible to believe that you're surrendering the firearm.
You're lying to a police officer from the precinct that you're supposed to turn it into.
No, besides that being inconsistent with the text of the statute, which acknowledges that there's an immunity for the voluntary surrender, that would create a gotcha game,
I
whereas...
think if you could argue that if he had said yes, and here I was turning it in, then I think you could have a pretty good argument under this statute. I don't know if it would win, but you'd probably get the charge, but...
If the legislature had intended for immunity to hinge on one's ability to have that communication with the officer, they would have just written that into the
I just think
statute.
that's a facts and circumstances case, right? So you look at what's in the record here to see if what you're arguing for is any reasonable view of that evidence. And there's no dispute as to what happened because there's a video and audio of it here.
No, there is a dispute that counsel's trying to present to the jury throughout this entire case, and the dispute is whether Mr. Debellis is telling the truth when he says he's on his way to the precinct.
But even
That's
if he
the
was,
dispute.
even if he was, accept that for a second in the hypothetical, and the cop pulls him over and he says, I don't have a gun. Why isn't that, no more you're taking this in, you're lying about having a gun now, and you're unlawfully in possession of it.
Because his immunity has already attached
But
at that
then
point.
why not when he robs the bank?
Well,
Because it's
there's
already
two-
attached.
there's
Because I
two-
was on my way, I stopped off, I robbed the bank, but I had immunity because I was going to turn my gun in.
If someone is in fact in the process of voluntarily surrendering the weapon, that is when the immunity attaches.
So then I robbed a bank. I'm doing it, I'm really going, and I see a bank, and I'm like, oh, well, I'm going to go in and I'll rob it, but then I'm going to go to the precinct.
Now, I think I understand the hypothetical better now. No, then you get prosecuted for robbery, but you have immunity for the weapon.
So you wouldn't get prosecuted for unlawfully having a weapon in that case?
No, because that's what the statute gives you immunity. You'd be prosecuted for armed robbery, though, and you would get a lot of time for that. But I mean, the legislature did not require an announcement.
You're pretty
So-
unlikely to persuade the jury.
Yes, and that's why that factual scenario is so much different than this, because this is just a man who's down on his luck, who's in financial trouble.
But you would get the charge in that case if you robbed a bank, because in your view, you would have immunity for the weapon.
if the person testifies to that effect, you would get the charge. But I just want to reiterate, though, there are a lot of, very ridiculous things that someone could testify to, and jurors decide whether it's ridiculous or not.
But the judge has to make a gateway determination, which is, I think, where we have a bit of a disconnect here. The judge has to make a determination whether that charge goes to the jury, whether there's a reasonable view of the evidence to give that charge.
Yes, and the reasonable view analysis is based on whether there's some evidence supporting the defense.
And
this is not
according to you, the some evidence is just him saying so. So on any gun possession case, moving forward, a defendant takes the stand and says, I was going to a gun buyback, regardless of what the other evidence shows, they're entitled to that charge.
And then it goes to the jury, like jurors assess credibility all the time, and that was the law under Watson at the time this
On
case was
every gun
tried.
possession charge, regardless of what the evidence is.
Just like in every homicide case, a defendant could, in theory, take the stand and say, I thought I saw a knife first, and then there is a charge on justification. This is how the jury system works, but those
No, that's
are...
not how the judges make a determination, especially in the justification charge, looking at the reasonableness and how the evidence was proffered.
The judges
But you're
look at-
saying in this situation, the judge doesn't have that obligation.
The judges don't look at credibility at the charges.
I'm not saying
There was a
credibility.
video in that case where the guy just has his hands up the entire time, and the defendant shoots him, and he says, oh, I thought he had a knife, but you can see his hands, and his fingers are spread, and there's no knife. Get a charge?
No, because you have video evidence conclusively proving that that makes no sense. Here, we just have a theory based on consciousness of guilt because he was not sophisticated in announcing his legal defenses at the time of his arrest. That is the kind of issue that goes to the jury. The scenarios that we discussed, they are ridiculous. I still think they would go to the jury. But this is not that. This is a sensible defense based on the facts, and it is the defense that counsel's trying to get before the jury. He just botches the analysis, and we get a directed verdict.
Thank you.
Thank you.